Gingrich and Owen wants case dismissed with a judgment. Let's see what they have to say. I'm the loud little ducky. Welcome, y'all. In the matter of Owens v. Echard, motion for judgment on the pleading and renewed motion to dismiss, assigned to the Honorable Judge Mehta, oral arguments requested. Legal arguments cannot be raised for the first time on appeal. To ensure a complete record, this motion raises a very simple question of law. Can a court sanction a litigant under Rule 26 for bringing a groundless case without first giving the litigant a warning and opportunity to drop the case? The answer to that question is no. Due to the traditional requirement of due process, i.e. notice and fair chance to be heard, Arizona law does not permit sanctions against a litigant without at least two prior procedural steps occurring first. 1, the litigant must be given warning that sanctions will be imposed, and 2, the litigant must be given an opportunity to withdraw the offending claim or pleading before sanctions accrue, which Woodnick has stated many a times that he told her he was going to. And it was past the days for her to dismiss it. It is undisputed neither of those procedural requirements were followed in this case. Really? Because I'm pretty sure Woodnick and Clayton dispute this. Undisputed means either side doesn't dispute the fact. You are the only one who says this, and Woodnick says the other. So it is disputed. As a result, even if Mr. Echard is 100% correct, and even if Owens was never pregnant and knew she was not pregnant at the time this matter was filed, this court cannot, as a matter of law, impose the sanctions Mr. Echard seeks. Therefore, pursuant to Rule 29C, Arizona Family Law, Petitioner Owens moves the court for an order granting judgment on the pleadings with respect to any requests for sanctions and or fees made by Respondent Echard, Mr. Echard, or Respondent, whether based on his motion under Rule 26 or based on the court's own motion under the same rule. Introduction. The court is familiar with the facts, so they will only be briefly summarized. Owens claims she had sex with Mr. Echard in May 2023. She claims multiple tests showed she was pregnant in June 2023, and after Mr. Echard refused to discuss the situation with her, Owens filed this establishment action on August 1st, 2023. The parties agreed to submit DNA testing in late September, early October 2023. Those tests were inconclusive. They were not inconclusive. Why does everybody keep saying they are inconclusive? The test said what the test said. And so whether you provided 2, 3, 20, is it always going to be inconclusive when it states little to no fetal DNA? Because I think if you have repeated test results saying that, I don't think it's inconclusive. This nonsense is really, really pissing me off. I am so tired of the misstatements of fact from Owen's side. Stop twisting things to fit your narrative and just state them as they are, as a matter of fact. Owens claims her pregnancy ended with a miscarriage shortly thereafter. Because the paternity issue in this case were moot on December 28, 2023, Owens moved to dismiss the case under Rule 36. On January 3, 2024, just 13 court days after his counsel first appeared, Mr. Echard filed a Rule 26 motion for sanctions. The motion claimed Owens fabricated her pregnancy, thus violated Rule 26b-3's requirement that her claims have evidentiary support. Mr. Echard's Rule 26 motion is set for an evidentiary hearing on June 10, 2024. Shortly after undersigned counsel was retained, it was determined that before his Rule 26 motion was filed, Mr. Echard failed to comply with any of the procedural prerequisites of either Rule 9c or Rule 26b-2. In short, Mr. Echard made no effort to meet and confer with Owens as required by Rule 9c and Rule 26c-2a, and he failed to give the mandatory 10-day written notice required by Rule 26c-2b. Finally, Mr. Echard failed to provide Owens with the opportunity to withdraw her petition as required by Rule 26c-2b. He filed the motion for sanctions without ever talking to Owens about the matter and without giving her an opportunity to withdraw her petition, as she has plainly, readily, and willing to do. She wasn't ready to do those things at that particular time. And this judge, I believe it was this judge, it might have been Judge G, has seen all of this stuff and has ruled that her case couldn't be dismissed. So you're not going to get a judgment when the court said, no, we're not dismissing this case. I mean, maybe they will, but I just don't see that happening. After discovering these errors, undersigned counsel met and conferred Mr. Echard's counsel and demanded the Rule 26 motion be withdrawn because it was filed without satisfying any of the rule's procedure prerequisites, despite some initial resistance, on April 3, 2024. Mr. Echard filed a motion to withdraw his Rule 26 request for sanctions. Thus, at present, there are no pending motions for sanctions of any kind before this court. Likewise, this court has not independently issued an order to show cause informing Owens that sua sponte sanctions are being considered. Maybe that will happen around June 10th. Given the odd posture, there is no procedural basis under which this court could lawfully award sanctions to Mr. Echard. This is true even if Owens lied about being pregnant. That is so because there is no dispute Mr. Echard failed to satisfy any of Rule 26 mandatory technical requirements which this court is required to strictly enforce, and this court can neither disregard nor retroactively fix those errors. Hypothetically, even though Mr. Echard has not moved for sanctions under ARS 12-349, it is clear sanctions could not be awarded under the statute either because Owens moved to voluntarily dismiss this action last December, thus precluding any award of sanction fees incurred after that date, ARS 12-349C. For these reasons, Owens is entitled to judgment in her favor on the issue of sanctions. No hearing is needed to reach that result because none of the facts requiring this result are contested. The issue is purely a matter of law. Okay, so he is not requesting that the entire case dismissed. He is not wanting a judgment on this case for its entirety. He just wants the sanction stuff to be dismissed and a judgment on that, saying I'm not going to because we can't, have Owens pay sanctions. But so it's just about this one thing, not the entire case. Discussion. Rule 29C provides a party may move for judgment on the pleadings within such time so as not to delay trial. When considering this motion, the court must assume as well-pleaded factual allegations in the challenging pleading are true, and if those facts do not permit relief as a matter of law, judgment should be entered for adverse party. Giles versus Marcy in 1999. Shannon B. Butler Holmes, and so forth. Here, for the limited purposes of this motion, the court may assume every factual allegation in Mr. Echard's now withdrawn Rule 26 motion is true. The court may assume Owens was never pregnant. The court may assume she filed this action knowing she was not pregnant, even though Owens disputes this. Under the clearly established legal standard of Rule 26, none of that matters. Even assuming Owens violates Rule 26 by filing this action knowing it was baseless, sanctions cannot be awarded to Mr. Echard because he failed to comply with the strict procedural requirements of Rule 26. That error ends the inquiry. If this court granted sanctions despite that error, the ruling would be erroneous as a matter of law and would be reversed on appeal. Owens is thus entitled to judgment as a matter of law in her favor as to the question of Rule 26 sanctions. Sanctions are not available under Rule 26 because Echard failed to comply with the Rule 11-26 technical requirements. Okay, so maybe she doesn't get Rule 26 sanctions. It doesn't mean that she can't get sanctions based on something else. So it's not saying there can be no sanctions ever in this court. He's just saying under this rule. And whether he's right or not, does that really matter at this point? The Clayton and Woodnick withdrew that motion for sanctions. So why is he still battling this out? As the court will recall, years ago, the standards for sanctions under Rule 11-1, for obvious reasons, cases interpreting family law Rule 26 are scant. And then it just has some citings. Okay. Before the family law rules procedure existed, were burdensome and erroneous. Before seeking sanctions, a party was required to 1. Draft a proposed motion for sanctions, 2. Personally serve the motion on the opposing party, and 3. Wait 21 days before the motion could be filed. During the 21-day safe harbor period, the alleged violator had an absolute right to cure the problem and escape sanctions by correcting or withdrawing the offending pleading, even assuming it was entirely groundless. I'm wondering, though, well, he filed for the sanctions in January and she found out she wasn't pregnant then, so no, never mind. My thinking was off on dates. If the violator opted to accept the safe harbor, the motion for sanctions could not be filed and sanctions could not be granted. See Sneller v. City of Bainbridge Island. Discussing former version of Rule 11 and explaining Rule 11 authorizes a court to impose a sanction on any attorney, law firm, or party that brings a claim for an improper purpose or without support in law or evidence. Rule 11C, however, provides a 21-day safe harbor period. Under this provision, Rule 11 sanctions may not be imposed if the challenged claim is withdrawn within 21 days after service of the sanctions motion. Emphasis added. That lengthy 21-day calendar, now a 10 court days waiting period, has always been and still is absolutely mandatory without exception. When a party fails to follow the strict procedural requirements of the rule, a trial court literally lacks the power to impose Rule 11 sanctions. Westerkamp v. Mueller. By extension, if a trial court awards sanctions when the safe harbor requirements have not been strictly followed, the result is a reverse error, and even if the underlying filing is completely frivolous, we must reverse the award of sanctions when the challenging party failed to comply with the safe harbor provisions, even when the underlying filing is frivolous. Holgate v. Baldwin. The purpose of Rule 11 and family law's Rule 26 safe harbor process is easy to understand. People, even lawyers, sometimes make mistakes. Whether a violation is intentional, malicious, or just accidental, Rule 26 was structured to encourage lawyers and litigants to promptly acknowledge mistakes by correcting or withdrawing the offended pleading without fear of devastating punishment. Notice here he says, whether it was intentional, malicious, or just accidental. Whereas before, he's like, he lied. They made mistakes and I don't make mistakes. So he's coming at this a little bit different than he did in the beginning when he wrote his other Rule 26 things. If a party makes a mistake but then voluntarily recants, which is obviously a good thing, the law rewards that wise choice by granting a safe harbor from further punishment, as long as a claim is withdrawn during that grace period. Sanctions cannot be awarded. And here's where I feel like some gray area is that I don't know about is she did ask to drop this case. I don't know if they ever put in a motion to withdraw this case. But she was told that they couldn't withdraw it. I'm going to look that up to see if there's ever a thing that said she tried to withdraw. Because I don't know that there's a motion to withdraw or drop the case. Might be. Even if the litigant knowingly brought a false, fabricated, groundless claim, the purpose of safe harbor is give the offending party the opportunity to withdraw the offended pleading and thereby escape sanctions. Roberts v. Gallagher, Barber v. Miller, so forth. Explaining safe harbor provisions protect the non-moving party from a motion for sanctions if party makes a timely withdrawal of contention that gave rise to the motion. Here, Mr. Echard disregarded this purpose and process. Indeed, he jumped the gun by filing a premature request for sanctions before and without giving proper notice to Owens, and without following any of the strict requirements of the rule. This is entirely undisputed. As a result, and a matter of law, Mr. Echard cannot now obtain sanctions regardless of whether Owens was or was not ever pregnant. B. Mr. Echard failed to comply with the Rule 26 requirements. I. Respondent failed to confer and failed to provide Owens with notice of her right to withdraw her petition. Mr. Echard filed his Rule 26 motion in January 30, 2024 without complying with either of the rule's two central requirements. First, Echard did not meet and confer with Owens as required by Rule 9c and Rule 26c2a. We know this because the motion never claimed such a conferral occurred. Second, Mr. Echard failed to give a written 10-day warning as required by Rule 26c2b because once again his motion never claimed such notice was given. The same issue was also mentioned on page 3 of Owens' response to Rule 26 motion shown here. Now, I might have to take Gingras' side a little bit on this part. Don't get me wrong. I think Owens should have other types of sanctions. I think she should have to pay attorney's fees and things like that for other reasons and wasting the court's time with lies and fraud and perjury. But when Woodnick told her that he was going to be filing sanctions against her, I don't think that Woodnick put in there, you have 10 days to drop this case, or else we're moving forward with sanctions. If he did, please remind me of that and where that is so that I can take back what I'm saying right now. But if he did just say, I am going to pursue sanctions, and he didn't state directly that she was going to be given 10 days, and after that 10 days he was going to file for sanctions, then maybe Woodnick didn't give her the full knowing of what was going to happen, so she knew that she could withdraw if she wanted to. And if that wasn't done, then Gingras may be right on just the Rule 26 requirements. Because as much as I'm not a fan of Gingras and I'm not a fan of Owens, we do want to make sure things are done right, because we don't want something on appeal switching certain things. If she is given sanctions, I want them to be by the law for the right reasons, and them not get appealed, and then her punishment goes away, because she's costed everybody so much money. So I hope we can agree, if all of this wasn't given properly and he didn't advise her of the 10-day period, then maybe Rule 26 sanctions shouldn't be given. But I thought all this was withdrawn and it was dropped. So I don't even know why he's still arguing this. Okay. So, don't hate me for agreeing, because we want things done right. We don't want things to happen on an error or a mistake or something. Says counsel for respondent certified that he met and conferred with petitioner on August 16, 2023, and with petitioner's previous counsel, Alexis Linval, on December 27, 2023. However, respondent's motion did not include evidence demonstrating that petitioner or petitioner's previous counsel were provided written notice of specific conduct alleged to have violated Rule 26B. Written notice is required under subpart C2B of Rule 26. Without such written notice, petitioner was not afforded time to cure any alleged deficiencies prior the filing of respondent's motion. We knew there is a filing that said that he was going to file for sanctions. He did for sure warn them about that. I don't know if he put in there the 10-day safe harbor period. I don't know that he has to say the safe harbor and 10-day warning. That would be interesting, because whether she had an attorney, like if she was with Linval or some other attorney, or if she was pro se, the thing with pro se is you can be treated as you're an attorney because you're saying that you don't need an attorney. So if he puts things in there about Rule 26 sanctions and she doesn't have counsel, and so that's why she didn't know about the 10-day warning, the court may find that, well, you knew that it was going to be Rule 26. You should have looked up and reviewed what Rule 26 was. Had you would have known about that. And so wouldn't it maybe treating her or writing his things like he's talking to an attorney, they may not have to put in there what Rule 26 is and all the requirements. They can just say, hey, I'm filing this. And in that case, the Rule 26 sanctions should stand. If you don't have to mention the 10-day warning, and you just have to mention that you're going to file them, and then you file them 10 days plus afterwards. I hope I'm making sense. Indeed, Rule 26C3 is explicit. In addition to the other requirements, Rule 26C3D requires that any motion for sanctions must prove compliance by attaching a copy of the written notice provided to opposing party under subpart C2B. Here, no such notice was attached to Mr. Echard's motion because the mandatory notice was never given. For that reason alone, this court lacks authority to even consider, much less award, Rule 26 sanctions. To be sure, this type of procedural failure is hardly uncommon. It happens all the time, which is why there is such ample case law cited infra explaining how such error eliminates the court's power to award sanctions. Under this rule, not all sanctions. As a matter of law, the fact that Mr. Echard failed to comply with the rule is conclusive of the issue. Mr. Echard failed to provide the mandatory 10-day court day safe harbor period. Even if Mr. Echard had conferred, which he did not, and even if he had given required written notice, which he did not, he also failed to notify Owens of the mandatory safe harbor period in which she had an absolute right to withdraw her petition and avoid sanctions. That fact precludes any awards of sanctions, Rule 26 sanctions, particularly given that Owens did in fact try to terminate this matter by moving to voluntarily dismiss the case on December 28, 2023, before Echard's Rule 26 motion was filed. Okay, so she tried to move to dismiss the case on December 28th. Sanctions were then filed January 4th, I believe they said. Does she have to voluntarily move to dismiss this case 10 days after the motion? Because she was denied being able to dismiss this case. So what happens then when you try to dismiss it and the court says no? That's a question I would like answered. Does it still mean that she shouldn't have sanctions filed against her because she did try to withdraw it? She did try to do the right thing and take it back. It's not doing the right thing. She just was caught in her lie. But you know what? My mistake. I'm not pregnant. I want to drop this case. And then the court says no. And that's not her fault that the court said no. In this way, Mr. Echard's bizarre actions are very similar to those described in Westerkamp v. Mueller. In Westerkamp, like here, the party who initiated the action, plaintiff tried to voluntarily dismiss the case. Like here, the party did not initiate the action. Defendant rejected the plaintiff's offer to dismiss. This is the same thing that happened here, where Owens moved to voluntarily dismiss before Echard's Rule 26 was filed. Like the party did not initiate the action. Defendant rejected plaintiff's offer to dismiss. Okay, so he's saying, actually, so the court didn't rule on it to be dismissed. Clayton said, no, we're not dismissing this. So because Clayton didn't want to dismiss it and he wanted to continue with it, should Clayton get awarded for wanting to continue this case in which Owens didn't? Should Owens be punished for that when she tried to get out? Maybe not. Okay, he might have a win on these Rule 26 sanctions. That might be the only win he gets in this entirety thing. But there's some controversy with this, you know. If he has to let her know about filing them and agree to letting her dismiss the case in order to get the sanctions and you have to tell them about the safe harbor period, I think Gingrich is right. You can't get sanctions for this. In Westerkamp, unlike this case, after the defendant rejected plaintiff's offer to voluntarily dismiss, but before any sanctions motion was filed, the defendant sent a proper written notice to the plaintiff warning of his intent to seek sanctions. 8 days later, with the safe harbor period of Rule 11, the plaintiff filed a motion to voluntarily dismiss the case, which, like this case, the defendant opposed. Despite the plaintiff's clear attempt to end the dispute by offering and then moving to voluntarily dismiss the case, the defendant still moved for Rule 11 sanctions. Given the posture, the district court rightly explained, the bizarre backdrop means the defendant's motion for sanctions must be denied. The court explained defendant's basis for even threatening to seek Rule 11 sanctions based on the alleged frivolous pleading, let alone formally moving for such sanctions, evaporated on March 2, 2023, when plaintiff's counsel offered to stipulate to a dismissal of the entire case with prejudice, emphasis added. Because the alleged wrongdoer in Westerkamp, the plaintiff offered to withdraw his complaint and dismiss the action before the defendant moved for Rule 11 sanctions. The court held that it was powerless to even consider, much less grant sanctions. Once plaintiff moved for voluntary dismissal, defendant was precluded from filing the Rule 11 motion. The underlying purpose of the safe harbor precludes a movement ability to move for sanctions, given the offering pleading that they had already been withdrawn via voluntarily dismissal. The posture of Westerkamp is not merely similar or analogous to this case, it is identical in this case. Like in Westerkamp, Owens commenced the proceeding, but then sought to voluntarily terminate the case by moving to dismiss it on December 28th, days before Mr. Echard's Rule 26 motion was filed. As the district court held in Westerkamp, the fact that Owens moved to withdraw her petition before any motions for sanction was filed caused the basis for Echard's motion to instantly evaporate. Once Owens' voluntarily dismissal was filed, Mr. Echard was precluded from even filing a Rule 26 motion, let alone obtaining sanctions. She did move to dismiss it. And Clayton said, no, we're continuing. And then he says, we're filing this because you filed it, when she did try to back out. So, yeah. Another helpful and even more closely analogous example is Radcliffe v. Rainbow Construction Company. In that case, like here, the defendant filed a motion for Rule 11 sanctions without first conferring and without providing written pre-motion notice to the alleged offender, the plaintiff Radcliffe. Procedurally, Radcliffe is identical to this case. Even though Rainbow failed to follow the procedural requirements of Rule 11, like Echard, the trial court held sanctions could still be awarded on the court's own initiative. Based on their view, the trial court held a literal application of safe harbor provisions was unnecessary in the case. Thereafter the trial, the court awarded $75,000 in sanctions to Rainbow. So, like I was saying, even if Owens and Gingrich win on this particular part, on the sanctions of Rule 26, doesn't mean that she's not going to get sanctions from the court and the judge on something else. It can still happen. So really, this Rule 26 thing it's nothing. Like, I can see why Woodnick was like, okay, we'll withdraw it. I don't give a crap about this. Like, we can move for sanctions and get sanctions some other way to punish her without this. So this getting dismissed and this being, approved and saying, okay, we're not going to give Rule 26 sanctions, like that's not going to happen in this case, it does nothing. It means nothing in this case other than the fact that that part's just not going to happen. It doesn't do anything else to the case. It doesn't quash a single thing. On appeal, the Ninth Circuit reversed. In doing so, the court explained when a party... Wait a minute. Literal application of the safe harbor. Thereafter, the trial court awarded sanctions to Rainbow. Well, okay, if they gave the sanctions in the Rainbow Ratcliffe case, then based on the Rule 11 or Rule 26, whatever, then yeah, I can see that being reversed. But if it was on something else, it wouldn't be reversed. On appeal, the Ninth Circuit reversed. In doing so, the court explained when a party wants sanctions under Rule 11, they must comply with all procedural requirements of the rule. Compliance is mandatory, not optional. When this does not occur, a trial court cannot fix the mistake for them by treating a defective Rule 11 motion as a sua sponte motion by the court, even though the rule otherwise permits the court to award sanctions on its own motion. The Ninth Circuit rejected any attempt to convert a noncompliance motion by a party to a sua sponte motion by the court as being inconsistent with the rules. We reject Rainbow's argument that the district court's order for sanctions can be interpreted as Rule 11 motion on the court's own initiative pursuant to Federal Rules of Civil Procedure 11C1B. This provision does not require 20-day notice. We reject Rainbow's contention because it was Rainbow, not the court, that initiated the award of sanctions. Correct in that case. But here, we have that motion withdrawn. Withdrew the motion for sanctions. So now that the Rule 26 sanctions are no longer on the table in the Owens v. Echard, anything that the judge motions for sanctions on is on their own accord, not in pursuant to Rule 26, because Rule 26 is not on the table because Woodnick took it off the table. The district court's discussion of the safe harbor provision and its order concerning sanctions serves to emphasize this point. It would render Rule 11C1A's safe harbor provision meaningless to permit a party's noncompliance motion to be converted automatically into a court-initiated motion, thereby escaping the service requirement. Because Rainbow did not follow the mandatory service procedure of Rule 11C1A, we reverse the award of sanctions. So, if Rule 26 was still on the table and she was awarding sanctions, it couldn't go, it wouldn't just automatically convert, which I think is probably why Woodnick withdrew that motion, so that it wouldn't convert and get reversed in appeal, that any sanctions that are done are going to be on behalf of the court, it's not going to be on behalf of anything that Woodnick or Clayton has filed. It will all be under the court's and the judge's discretion. I think that's why it got withdrew, not because of threats. It's a chess game. The same rule governs here, and it is dispositive, substantially and procedurally. The posture of Ratcliffe is identical to the case. In both matters, a party moved for sanctions without complying with the safe harbor provisions of the rule. Although Mr. Echard later withdrew his Rule 26 motion to avoid sanctions himself, the error cannot now be fixed by converting this defective Rule 26 motion into a request under some other provisions, such as the court's own motion, as in Ratcliffe. Such a result would unlawfully deny Owens the safe harbor benefit to which she is absolutely entitled to as a matter of law. No further discussion is necessary for the court to resolve the Rule 26 issue and deny the award of sanctions under Rule and on any other hypothetical basis, such as ARS 12-349, because no such motion has been brought. But simply awarding sanctions after a party has moved to withdraw or dismiss their pleading is a direct violation of the safe harbor structure and purpose of Rule 26 and is not permissible under any circumstances. Based on these undisputed facts, Owens is entitled to a judgment on the pleadings on the issue of sanctions. Accordingly, this court should grant judgment in the favor of Owens pursuant to Rule 29C, and either dismiss this matter as no further issues remain pending, or at least enter a partial final judgment in favor of Owens and against Echard as to the Rule 26 motion pursuant to Rule 78B, allowing the entry of a partially final judgment if other claims remained outstanding, which I think is what the judge should probably do here. Rule on the Rule 26 sanctions. Put the judgment in for this. Okay, we aren't going to do that. But still keeps the case open because we do have other issues that remained outstanding, other claims that remained outstanding. But to dismiss everything in the case just on this, absolutely not. And I don't see the judge doing that. I can see them just ruling in favor on the Rule 26 motion. They may not rule on it until the day of, granting and denying motions. We're granting in part, denying in other parts. We've seen those motions before. Any other future request for sanctions is untimely. Because Echard did not follow the procedural requirement of Rule 26, sanctions cannot be awarded under that rule. As explained above, the problem cannot be retroactively fixed by converting the defect and now withdrawn motion into one seeking relief under other authority. Doing so would violate Owens' safe harbor rights, regardless of whether sanctions might hypothetically be available under some other authority. See Radcliffe, citing Barber v. Miller. However, presumably, Mr. Echard may intend to bring a new motion for sanctions under some alternate theory. If that is his plan, it is worth noting that in addition to his procedural requirements, Rule 11 and 26 also contain implicit temporal restrictions, such as motions must be brought with a reasonable amount of time after a violation is discovered. Any unfair delay in seeking sanctions renders the request untimely. The rules exist to promote judicial efficiency to serve the underlying purpose of the safe harbor, i.e., to incentivize the offending party to withdraw their claims as soon as practicable, and therefore avoid needless satellite litigation, as has occurred in this case. For that reason, courts routinely deny requests for sanctions when they are made too late in the proceedings to serve the intended purpose of the rules. To promote judicial economy, a sanction motion should, as a general rule, be filed promptly upon discovery of the alleged violation. See Federal Rules of Civil Procedure 11, Advisory Committee's Note 2, 1993 Amendment. Ordinarily, the motion should be served promptly after the inappropriate paper is filed, and if delayed too long, may be viewed as untimely. Promptness in the filing sanctioned motion serves inter alia to deter further misconduct and to foster judicial efficiency by allowing courts to address and resolve what are typically fact-intensive disputes close in time to underlying events. Here, the plaintiff's sanctions motion was based on a purportedly wrongful conduct by O.R. Hubbs' counsel that had occurred a year and a half earlier, a delay that is excessive on its face. Requiring prompt action by litigant whenever a Rule 11 violation appears, become promptness in filing valid Rule 11 motion, will serve to foster efficiency. Denying is untimely as a matter of law, extremely late, Rule 11 motion filed more than 17 months after the offending conduct. Well, I don't think anything's going to be filed 17 months after offending conduct. In this case, shortly after the petition was filed on August 1st, 2023, if Echard truly believed Owens violated Rule 26 by filing this action knowing she was not pregnant, he could have and should have immediately served her with Rule 26 complaint demand explaining he would seek sanctions unless she withdrew her petition. Had he done so, this matter would have ended almost 6 months ago, with zero fees/costs incurred by either party. I don't know if he would have filed them back in August. I don't know that she would have dismissed it then. Maybe that's what should have happened. But Clayton was on his own then, so he didn't file it. He probably didn't know to file it. But this wouldn't have been a good argument then, because she would have kept on with this case and not withdrawn it within that 10-day period, and she could be sanctioned. Because at that point, she wasn't going to let go of that in 10 days. She was going to continue on. And we'd still be here in this same boat, basically. Except without this stupid motion. I mean, it's not stupid per se. It's actually might be one of his more, one of his better motions. Now more than 9 months after the action was filed, and nearly 5 months after Owens moved to voluntarily dismiss the case, the parties have needlessly incurred substantial attorney's fees and costs, which only continue to grow every day. Those costs and fees would not have incurred by either party if Echard had simply served Rule 26 complaint demand at the start of the case, or if he had agreed to allow Owens to voluntarily dismiss the case at the end of December. And Clayton wasn't going to do that, because just her dismissing this case didn't prove that what she was saying was false. So I see why he continued with it. I think it's for the good that he did continue it. It sucks money-wise, but I think this needed to happen. In this bizarre posture, and in bearing in mind there is no pending motion for sanctions filed by Echard, any judicial efficiency that would be promoted by punishing Owens for filing this action on August 1st, 2023, or by compelling her to withdraw her petition, as she has already tried to do, has completely vanished. Thus, although Mr. Echard has not brought a new motion for sanctions since the previous one was withdrawn, any new motion would be untimely as a matter of law. Conclusion. For all the reasons stated above, petitioner moves the court for an order granting judgment as a matter of law to Mr. Echard's Rule 26 motion for sanctions, including any such request to extend is based on the court's own motion or other authority. Dated March 10th, 2024. All right. So let's just grant Owens' motion on this. Let's just give this to them. They might be unbearable after getting this win. Well, see, I told you so. But this getting granted doesn't hurt anybody. It doesn't hurt Clayton's case. It doesn't undo anything that has happened in this case. The June 10th stuff will still be happening. So making it to where they can't get Rule 26 sanctions, like, okay. Like, whatever. Move on. Shut up and give them a little bitty win. Then we have the good faith consultation certificate. He's made a good faith attempt to resolve the issues in the motion by consulting with opposing counsel, but those efforts were not successful. And then he copied Woodnick and Rainey and stuff. And he signed them. So that is where he wants dismissal and a judgment is on the Rule 26 sanctions. It's not that big of a deal. That motion is a nothing burger, and whatever happens with it happens with it. It doesn't affect anything. Our quote of the day is, don't let idiots ruin your day. We did with lots of idiots in this case. And we don't need to let them ruin our day. Because if you know that you're on the right side of justice and you can weigh evidence and things on an unbiased thing, looking at it from both sides, which is what I try to do. Some days I may be really, really opposed to Owens and Gingrich. And there may be other motions where I don't agree fully with what Woodnick says or what Clayton says. That doesn't really happen much. But I like to look at things on an even playing field. I'm not just going to say everything you say is garbage, you can't be right about anything and you can be right about everything, because that's just not how it works. I will give credit where credit is due. And this motion, although long and lengthy and boring, he wasn't really aggressive in that motion, so points for that. He was kind of calm in that motion compared to other ones, and he was just laying out the facts. And I think if that's what the rules say, then grant it. If that is not what the rules say, then don't grant it. But we are not going to let idiots ruin our days. We're going to continue to have great days. And I hope you are having a great day. It is raining here, so outside is gloomy, but it's still a good day all in all. And that is it. Hit that like button, subscribe, turn your notification bells on, and I will see you in the next video.